So what I'll try to do this morning, once the slides come up, is talk about the relationship between blockchain technology and the GDPR. And what I'll try to do in the next 30 minutes or so is, first of all, give a very brief, very cursory introduction to what blockchains are, focusing on the characteristics that are most interesting from a data protection perspective. I will then talk a little bit about why many people think that there's a sort of general tension between the overarching scheme of the GDPR and the nature of blockchain technology. And I'll illustrate this by sort of picking 4 concrete areas of data protection law, which are those of data minimization, purpose limitation, the right to erasure, and also controllership. And then afterwards, I'll also say a few words as to why blockchains might actually also be offering some benefits that are interesting from a GDPR perspective. So let's get started. So what is a blockchain? In essence, a blockchain is a shared and synchronized digital database that is maintained by a consensus algorithm. And so essentially a good way to imagine how this technology functions is to sort of see it as a database that doesn't just exist in one location, but which exists in parallel on many different computers. And in principle, all of the computers share a full copy of the entire data on the database. And those computers can be located in many different places, including many different jurisdictions, which of course creates a whole range of interesting legal questions to this. So blockchains as a database structure try to produce resilience through replication, right? So by replicating the data and by storing the data on many different servers, the idea is that even some of those computers go down, if some of those computers are destroyed, you still keep the database as such because it exists in many different locations. One really important feature of blockchains, particularly from a GDPR perspective, is that they are append-only databases. So in principle, it's a database to which you can always add data, but from which you can only destroy data or change data in very extraordinary circumstances. It's very hard to change the data that is contained in a blockchain, which of course is really interesting from the GDPR perspective if you think about the data controllers' obligations under Articles 16 and 17 GDPR. Another interesting feature of blockchains is that they use timestamps. So they contain mechanisms that allow you to see who did when at what time, who did what at what time to the database, and sort of trace that. And then one sort of caveat I wanted to have at the beginning of my presentations is that there's no such thing as the blockchains, right? So blockchain is really a class of technologies that can have very different technical properties and that they also have different governance arrangements. And so if you're trying to sort of determine whether a specific blockchain that's used in a specific context is compliant with the GDPR, you really need to look at the specific features of the blockchain that's being used in a particular context. And also, so often this is introduced as something that's completely novel and completely new, that has no sort of similarities to things that we've known before, but I think it's also important to briefly mention that actually blockchain is a sort of collage of different technologies that have been around for a few decades now. And so I said that blockchains are a class of technologies, and usually sort of they're divided in 2 different categories. So on the one hand, there's public and permissionless blockchains, and on the other hand, there's private and permissioned blockchains. So essentially, the difference between private and public is that on public blockchains, the data that's contained on the blockchain, even though it might be encrypted or even though it might be hashed, is visible to anyone who wants to access it. Whereas in private systems, this isn't the case. And the difference between permissionless and permissioned is in essence that in order to sort of join the network and to add data to the network, in permissionless blockchains, you don't need permission from anyone to do so, right? You can just do it, whereas in permission systems, there's generally a central gatekeeper that decides which parties can join the ledger. And those features, of course, are quite interesting from a GDPR perspective. Now, of course, as you know, blockchains are debated technology, right? So on the one hand, you have people that are deeply skeptical about the technology, as you can see from this slide. And then on the other hand, you have people who are sort of profoundly optimistic about what the technology might be, right? So some have gone as far as to say that blockchains will change our life, the economy, and the world. Now, which one of those is true? It probably lies somewhere in the middle, as things always do. But I'm not so much concerned today with sort of the very future of blockchains. I'm more interested in assessing them from the perspective of data protection law. And really, I think there's two reasons why this is interesting to do. First of all, because it's a practical question. Some people want to use blockchains in their business operations, so of course the question becomes, well, how can they do so in a way that respects the regulation? But I also think that if you actually try to map the GDPR to blockchains, you can learn very interesting things about the GDPR, as I'll try to illustrate, because really I think that doing so highlights some of the pain points that we have in the regulation. And the reason why this is the case is because really I think there's two overarching reasons why there is a tension between GDPR and blockchain. And this tension, I should say, is something that has been avidly debated over the past couple of years. It's something that regulators have talked about, the public sector have talked about, something that has gotten quite some media attention. And this tension, I think, is essentially due to two factors, right? So on the one hand, blockchains try to achieve decentralization in decentralizing the data on the different computers, but also often in decentralizing the governance that relates to those databases. And the GDPR, of course, is a legal framework that has a history that goes back really, at least until 1995, but really that was already based on earlier legislation. So there are certain implicit assumptions in this legal framework. And I think one of the implicit assumptions is that generally you will have one legal entity that's responsible for what happens to one specific data point. And this is something that isn't really the case when blockchains are used. And then the second overall tension that you can see between this technology and the regulation is that between mutability and immutability, right? So in the GDPR, there's this legal obligation to change or erase data in certain circumstances, yet blockchains are purposefully designed to make this impossible or at least very hard. So let's look at how this tension plays out in different areas of the GDPR, right? So one of the core principles of European data protection law is that of data minimization. So we know that Article 5, paragraph 1c says that personal data shall be adequate, relevant, and limited to what is necessary in relation to the purposes for which they are processed, right? So the idea is that you should keep the data that you're using, the personal data that you're using in a specific context, to a minimum. And there's two reasons why this is hard to achieve in blockchain networks. So the first one is that those are append-only databases. So the idea is that it's a database that continues to grow and grow and grow, but from which you can't really remove any data. And the second one relates to its resilience by replication feature, right? So it isn't just a database that continues to grow, it's also a database that's replicated in many different places. So you have copies of the data in many different places. And of course, these are features that aren't ideal from a GDPR perspective. The similar sort of tensions can be identified when we look at the purpose limitation principle that we find in Article 5.1b. And this tells us that personal data shall be collected for specified, explicit, and legitimate purposes and not further processed in a manner that is incompatible with those purposes. Now, when you add data to a blockchain, you have a purpose in the sense that you add it to the blockchain for a specific purpose, right? So let's say the example of a transaction, right? You want to have a transaction, and for that you need some kind of personal data, at least the public key of the individual that this might relate to. So that's the initial purpose. However, what then happens is that the data continues to be stored in the blockchain, and we know that storage qualifies as processing from a GDPR perspective. So you have sort of secondary processing. And it will also be processed whenever the network reaches consensus on whether new data should be added. And the question is whether you can make the argument from a GDPR perspective that not just the initial purpose. The transaction falls within the purpose specification idea, but also the secondary use for the sort of maintenance of the ledger. And I think the answer to that question isn't entirely clear if you look at how purpose limitation has been interpreted. And then, of course, there's the tension that has gotten by far the most attention so far, which is that between the obligation in Article 17 GDPR to erase data in certain circumstances, so this is the famous right to be forgotten, and the fact that blockchains are designed to render the modification of data extremely hard. So Article 17 GDPR tells us that the data subject has a right to obtain from the controller the erasure of personal data concerning him or her without undue delay. And now, what many people have pointed out is that in order to determine whether you can actually comply with the Article 17 obligation in relation to blockchains hinges significantly on how the terminology of erasure is actually to be interpreted from the perspective of the GDPR. And this is something that really is far from evident, right? So on the one hand, you might argue that erasure, which isn't defined neither in the recitals nor in the text of the GDPR, is to be interpreted as a sort of common sense understanding of erasure, namely the destruction of data. However, that is not necessarily the case, right? So when you look at the Google Spain judgment from 2014, in that specific case, of course, the question didn't relate to the erasure of data, it just related to the delinking of the search results from the Google search algorithm, right? So you might interpret this judgment as saying that you don't always have to have sort of destroyed the data, but you could also look at this judgment and saying that this wasn't actually a question that was within the facts of the case at that time. And then if you look at what different national data protection authorities have said on this issue, it also becomes quite clear that between them, there's not necessarily agreement as to how erasure is to be interpreted. So the British ICO, for instance, has maintained for a number of years now that if you put data beyond use, then this equals an erasure of the data for the purposes of Article 17 GDPR. And for instance, one way of putting data beyond use would be to anonymize it. And in a more recent opinion from December last year, the Austrian Data Protection Authority also stated that you can erase data for the purposes of Article 17 by anonymizing it. Now, of course, what is anonymization under the GDPR is an entirely different can of worms. We don't also sort of really know what that means often, but at least some data protection authorities have taken the position that erasure doesn't necessarily equal the destruction of data, right? It can be achieved by other means whereby you render the data inaccessible or whereby you change its character from personal data to anonymous data. And if this is the case, then there could actually be ways to comply with Article 17 in relation to blockchains. And the only data protection authority that so far has issued an opinion on the relationship between blockchains and the GDPR is the French Data Protection Authority. And the French Data Protection Authority suggested that in order to comply with the obligation in Article 17 GDPR, it isn't actually necessary to erase the data, but that you could choose alternative means of doing so. And the concrete example that they suggest is that where you have encrypted data on a blockchain, you could destroy the private key in a controlled setting, and that would allow you to achieve the anonymization of data. Now, of course, the question is whether this is something that sort of falls on consensus at the supranational level, and also whether it's something that the court would accept. And one judgment I want to mention, which is really interesting in this respect, is the Novak judgment of the court from 2017, in which wasn't specifically concerned with Article 17, but in which the court nonetheless said in a side sentence, really, that erasure equals destruction, right? So really, I think what the takeaway from this is that we don't really know what erasure requires from a technical perspective under Article 17, and depending on how you interpret it, it will be more or less easy for blockchains to comply with this requirement. Now, another area of data protection law that I think is really interesting to look at through the lens of blockchain technology is that of the data controller, and specifically the identification of the data controller in a polycentric network in which you have many actors that influence on the data processing. Now, Article 4, Paragraph 7 GDPR tells us that the data controller is the natural or the legal person, public authority, agency, or other body, which alone or jointly with others determines the purposes and the means of personal data processing. Now, when you look at the text of Article 4, Paragraph 7, really what you sort of see is that it appears to indicate that both the purposes and the means are sort of criteria on an equal setting to determine who is a controller, right? So Article 4, Paragraph 7 appears to indicate that the data controller is the entity that determines both the why and the how personal data is being processed. Now, if you look at how this has been interpreted by the court and other regulatory authorities throughout Europe, a somewhat different image emerges to the extent that much more emphasis has been placed on the purposes of personal data processing as opposed to the means. And this, I think, in part is due to the rationale that the court made explicit in Google Spain and many subsequent judgments, whereby there is a need to adopt a broad definition of the notion of controllership to ensure the effective and the complete protection of data subjects. Now, before I sort of try to apply this to blockchains and sort of highlight what the interesting elements of this are from a blockchain perspective, I think it's also interesting to look at the notion of joint controllership under the GDPR. So Article 26(1) GDPR tells us that where it's possible that there are two or more controllers in relation to data processing, and this arises where those controllers jointly determine the purposes and the means of processing. And really, this is an interesting area of data protection law right now, I think, to the extent that there's a number of recent judgments in which the court has interpreted this notion in interesting ways. Right? So in the Wirtschaftsakademie Schleswig-Holstein case, the court essentially indicated that where you agree to the means and purposes of data processing that have been specified by someone else, and where you benefit from this agreement in one way, then you can be considered to independently also determine the means and purposes of data processing, and accordingly, you become a controller. Now, this was followed, I think, just a few weeks afterwards by the Jehovah's Witnesses case, in which the court reaffirmed this rationale, this very broad interpretation of the notion of joint controllership, and it also added that in order to be a controller, you don't actually need to have physical access to the data, to the personal data in question. And here again, the court used the rationale of the earlier case, so it says that a natural or a legal person who exerts influence over the processing of personal data for his own purposes and who participates as a result in the determination of the purposes and means of that processing may be regarded as a controller. So really, the court's recent case law on joint controllership embraces a very broad take on the concept. And you might say that anyone who agrees to someone else's data processing and benefits from that for their own purposes becomes a data controller. And this is something that the court might further specify in the upcoming Fashion ID judgment. But I think it's interesting to highlight that in this case, Advocate General Bobek, who already issued his opinion, sort of criticized the court's broad definition of joint controllership in the earlier case law, and said that when we push this rationale to its extreme, then the only criterion that makes you controller is whether the data processing has been made possible through your actions. Now, let's try to think about what this broad definition of both controllership and joint controllership means in the blockchain context. And essentially, I think this is the area of the intersection between blockchains and the GDPR on which there's the least consensus. So many people have thought about this. Many people have written about this. but essentially everyone reaches the conclusion that it's extremely hard to identify who the controller is in a blockchain network, particularly in a public and permissionless blockchain. Now, of course, in order to really identify the controller, you would have to look at each specific use case of blockchain technology, look at the technical features, look at the governance arrangement, look at sort of the purposes of the processing, and determine controllership on a case-by-case basis. But I think nonetheless, it's possible to sort of think about this in a more general way. Now, among the parties that we have in blockchain networks that could qualify as controllers are the following. So some people have suggested that the core developers, so the people that sort of create the software, particularly in public and permissionless networks, could qualify as data controllers. I'm a bit skeptical of this argument to the extent that, yes, they have a decisive influence over the means, to the extent that they determine what the software looks like, but they often don't determine the purposes of data processing. So they make something available, they make a tool available for others to use, and for others to use in accordance with their own purposes. Then we have the miners, which again have a decisive influence over the means, also through their active role in blockchain governance. But again, in most cases, they won't have an influence over the purposes of data processing in a specific influence. And then there's the nodes. So the nodes are the computers on which the blockchain is stored. And I think there's a relatively broad agreement that nodes might qualify as data controllers to the extent that nodes determine their own purpose for participating in the network, and also to the extent that they have access to all of the data that's stored on the ledger, even though it might be encrypted and even though it might be hashed, and they can do with this data whatever they want, essentially, right? And realize their own purposes in that setting. Now, I think it's also important to point out that what I've said so far relates to the infrastructure level of the blockchain, right? So it's really what happens if we look at the infrastructure itself, and where a user, for instance, directly engages with the blockchain, which would be the case if you, say, decide to buy some Bitcoin or something like that. However, you often also have an application layer that's based on top of the blockchain. And I think where that is the case, there's a strong argument to be made that whoever is the legal person that controls that application becomes the data controller that's being processed through the application, in line with what you would have in sort of conventional internet settings. Where you don't have the implication and where a user directly engages with the network, with the infrastructure, many people have also highlighted that the user, which could be a natural person, might be the data controller. And this is, for instance, what the French Data Protection Authority has maintained in its opinion on blockchains and the GDPR. And this then raises a really interesting question. So if you accept that the household exemption can't apply to such settings, which I personally think is the case, because if you look at the court's case law, the court has continuously said that the household exemption can apply where you make data accessible to an indefinite number of people, and this is exactly what you do, at least when you use a public and permissionless blockchain. So if you accept that the household exemption can't apply in those settings, then you might have a situation whereby the user becomes the data controller in relation to others' personal data, such as, for instance, someone else's public key where they engage in a crypto asset transaction with them, but also in relation to their own personal data. And I think this is a really interesting conclusion, because I'm not convinced that that is actually something that is or should be possible under GDPR, if you look at the overall framework as a sort of a legal framework that tries to protect data subjects from what others might do in relation to their personal data. So really the takeaway from this is that controllership, you have to determine it on a case-by-case basis, but it's difficult and there's little agreement as to this stage as to who potential controllers should be. Now, of course, determining the identity of the data controller is one thing. The second question is, what happens if you actually are a controller? And one thing to highlight is that, for instance, going back to this, these actors, none of them really has complete control over what happens over the personal data. So for instance, if you were to accept that a node is a data controller in relation to the personal data stored on the blockchain, nodes actually won't be in a position to say, give a right to request for access under Article 15, because all nodes will see is encrypted and hashed data, and they might not be in a position to actually relate that data to the data subject. And similarly, they are also able to independently, for instance, operate directification or erasure of data. So one interesting element to highlight is sort of the factual inability of those actors to do some of the things that are required under the GDPR. And the other thing that we really see when we try to map the responsibility of controllers to blockchains is the tension that we have in Article 26 GDPR, right? So the first paragraph of Article 26 tells us that where there are joint controllers that jointly determine the purposes and the means of processing, they have to conclude an agreement that sets out their respective responsibilities. Then the third paragraph of Article 26 GDPR tells us that irrespective of the terms of the arrangement that is foreseen by paragraph 1, the data subject may exercise his or her rights under the regulation in respect of and against each of the controllers, right? So if you look at particularly blockchains that are public and permissionless, and you recognize that there's many different actors and that many of those actors might actually qualify as controllers, then there's this practical question of, well, who of those many actors should the data subject actually address? And what happens if the data subject decides to address one of the joint controllers that's factually unable to comply with the obligation that it has under the GDPR? And the answer to this are probably governance structures between the different actors that set out their respective interactions and create channels of communication. But this is something that we don't yet have, again, at least in public and permissionless blockchains. It's easier in the private and permission ones. Now, so really what I wanted to highlight so far is that when we try to map the GDPR to blockchains, what we see is that there's a number of tensions, and those tensions relate mainly to the key factors of the centralization against decentralization and mutability against immutability elements. Now, of course, this are topics that haven't escaped the attention of regulators and a whole range of actors in this area. Many people have actually called for a revision of the GDPR, so there's been industry voices who have said, the existence of the GDPR stifles blockchain innovation in Europe. It will make Europe lag behind compared to other jurisdictions on this planet that don't have the GDPR. So really, we need to change or abolish the GDPR in order to make Europe a competitive actor in the data-driven economy. Now, I don't think that is necessarily the case, and this is something that relates back to the discussion that we had yesterday, a bit in the context of AI, to the extent that the GDPR is a principles-based regulation. It has a whole range of co-regulatory mechanisms that are designed to address the emergence of new technologies, such as code of conduct or certification mechanisms. And that many of the tensions that we have seen, I think, are problematic, but they're not insurmountable. So I think that if there's, on the one hand, more guidance from a regulator as to, for instance, how the terminology of erasure is to be interpreted, and if on the other hand, you have sort of more efforts on behalf of those developing blockchains, I don't think it's impossible to sort of surmount those tensions and come up with solutions that are feasible in relation to blockchains, but also respective of the GDPR. And before I finish, I just want to talk for a few minutes about the sort of more positive aspects of the relationship between the GDPR and blockchains. Now, of course, most of the discussion today has focused on the tension that exists between them, but people are also starting to realize that blockchains are actually a tool, blockchains are actually technology that might have a range of advantages for some of the GDPR's objectives. And again, I want to repeat that, blockchains are a class of technologies. It's a technology that you can use in different ways. And blockchains are by no way automatically good for data protection, and they're in no way automatically beneficial for the objectives of the GDPR. But they're very malleable technology that can certainly be fashioned to realize some of those objectives. And so, for instance, one benefit that blockchains might have from a data protection perspective is that the mechanisms it provides, such as having a ledger that's shared between many actors that has timestamps, etc., might actually be a good way to introduce more accountability and transparency where personal data is being handled, right? So it might be a way that allows data subjects to, for instance, see who accessed their data at what stage, and as such, it might also be interesting for data controllers to comply with Article 15. It's also interesting for data controllers from the perspective of the data controller obligations in Article 24. So again, the accountability and transparency elements that those tools might offer might be a good way for data controllers to actually sort of retroactively prove what has happened with some personal data items, and to prove that they have acted in a manner that's compliant with their obligations under the GDPR. And then one broader overarching feature or benefit that the technology might have is that it might be an efficient tool for data sharing. Right? So we all know that data sharing is a really hot topic nowadays. It's something that the EU, for instance, explicitly wants to encourage, at least when it comes to non-personal data. And there's a range of pilot projects, some of which are funded under the EU's Horizon 2020 mechanisms, that try to use blockchains as this distributed database controlled by many actors to actually incentivize the sharing of data between various actors, also in view to facilitate the training of computational learning mechanisms. And so this is something that has been much less explored than detention, but I think it's nonetheless interesting to sort of keep an eye out to what happens in this area and see how actors are now trying to use the benefits of this technology to actually comply with some of the obligations in the GDPR. I'll stop here. I'm looking forward to your questions, and I also apologize in advance. I'll have to leave straight after the break, but this is where you can find me if you have any questions. I'll be happy to continue the conversation.